I was worried you were again gone. We can start?
Oh, you can hear me now, right?
Yes, yes. Thank you. Okay. Very good evening to all of you. I am Saraswati, Secretary General of the Madras Chamber. Let me, at the outset, wish you all a very, very happy new year. Probably this is the first event, I should say, maybe barring our expert committee and general committee meeting. This is the first event for the year. Hope we all have a safe year ahead. And a very special thanks to Madam Ms. Chitra Narayan for accepting our invitation to discuss probably a very, very new topic, I should say. A very this also you are starting with a very fresh topic. But as far as the Madras Chamber is concerned, as you know, ma'am, we have met earlier. The Chamber's arbitration services were started long, long ago. Even our original charter, I don't know when it was updated, has the mention about it. But at least since 2000, we have been doing. And 2021, I should say, we opened a new leaf with an exclusive arbitration, mediation, and conciliation center. Madras Chamber is a big name, but we have a very catchy logo, MAMC. And we have been organizing a number of educative programs like this. This is the 14th in the series, if I am right, monthly series. And we started with what is an institutional arbitration, what is the ADR, and now we are here on a very, very current topic, I should say. And we have a wonderful facility. Maybe Mr. Anand will explain a little more on that. And we also have a wonderful, competent registrar there and a very helpful and aiding governing council. So I would stop here. I would request Mr. Anand Gopalan to say a few formal words and start the program, and we will now then leave it to Madam. Thank you so much. I request all the participants to post your questions. I'm sure we will have a number of them in the Q&A box, and during the question and answer session, Ms. Savita will moderate the session. Thank you so much once again. I will sign off. Request Anand to take over the screen. Thank you.
Thank you, Ms. Saraswati. Good evening, everyone. Good evening, Chitra. Thanks for accepting our invitation and being with us here today. Yes, MAMC has been in picture for some time, but it's been really active for the last nearly 1 year, and with the new physical center with rooms and all the digital media equipment that is required on today's completely with video conferencing and every whatever you name it, the infrastructure is there. And as part of it, we've been doing various programs also, not only to promote MAMC, but also to educate on various ADR methods that are there. And as part of it, mediation. Well, the word mediation is not something that I think we are very familiar with in India, at least for a person like me who's a core litigation lawyer. It's not something that we really like to hear because it puts us all out. But then it's something that I think brings about peace to the client, and there's a lot of disputes that come about. It's not something that is mutually agreeable to parties and you bring out a resolution. I think that also helps us professionally to, a kind of satisfaction professionally that we get even as lawyers. So, and when we are just discussing about this draft bill, Chitra's name is the only name, in fact, came to us because she's been part of MAMC in the recent years as well. We have been troubling her for some as arbitrator in different ways, and of course her own credentials to speak about mediation. For those, Chitra completed her law degree from National Law University, Bangalore, one of the early batches, I guess, and has done her master's with a Chevening scholarship. These are all her academic credentials, something like people like me, keeps wondering how you do these things. She enrolled 25 years back, has worked in various commercial corporate firms. She's been a partner, then she has her own setup today. She's an independent practitioner. But more than that, as part of the mediation, many of you know that Madras High Court is the first High Court to have its own mediation center, which was started in 2005. Chitra has been part of it from 2005. So that thing. And not only that, she's also written books. Her latest book in 2021 on mediation, the mediation policy and practice, talks about what is the practice in India, and what is cross-border mediation is something that I'm really fascinated about. I plan to buy a book and read about what it is. And then she's also been part of this committee where this draft mediation bill has come about. So we thought that the best person who could speak about this bill is Chitra, and we're grateful that she accepted our invitation and is here today to talk about the bill. Thanks, Chitra, once again. It's all yours. Yeah.
Thank you so much, Anand. Thank you, Ms. Saraswati. Thank you, Madhumati. Good afternoon, everyone. I'm so happy to be here to talk about the draft mediation bill. I have a small presentation that I will share. Please let me know if you're able to see it. Is it visible?
Yeah,
Yeah, it is. But if you could make it a full screen, it would be better.
Yeah, I was just telling Madhu that I like to see what the next slide is that's coming up, so I tend not to do that.
Okay, that's fine.
So it's not a distraction. I'll continue.
Yeah, okay, fine.
Yeah. So before I talk about the draft mediation bill, I thought I will talk a little bit about mediation because there is a tendency to mix mediation with arbitration. There's also this confusion about what mediation is and what conciliation is. So I thought I would start with describing the process of mediation. So I'm taking this definition from the Mediation Act in Ireland. It's a 2017 law on mediation, which defines mediation as a confidential, facilitative, and process in which parties to a dispute, with the assistance of a mediator, attempt to resolve to reach a mutually acceptable agreement to resolve a dispute. So if one looks at what this process is about, there is obviously a conflict or a dispute between persons. They take the help of a third person who is defined as a neutral or as a mediator. The neutral helps these parties to resolve the dispute. The neutral doesn't have the power or the ability to decide the dispute for the parties. So when you distinguish it from arbitration, the neutral who the parties appoint is able to decide the dispute for the parties, is able to tell them that this is how I will, this is what has gone wrong, this is the person who has breached the agreement, for instance, this is the remedy that I'm giving. But the mediator does not have such powers. The mediator only facilitates the resolution of the disputes. Just to sort of reinforce this next slide deals with the definition under the Singapore Convention, which defines mediation as a process, irrespective of the expression used, or the basis upon which the process is carried on, where parties attempt to reach a settlement of their disputes with the assistance of a third person or persons, the mediator, lacking the authority to impose a solution upon the parties to the dispute. So I tend to use this diagram when I teach mediation as well. So I tend to use this diagram to explain what the mediation process is about. So you have these gears that really work mediation and take it through. One is that mediation is a voluntary process. Unless parties want to try mediation and try to resolve their disputes with the help of a third party, you don't have mediation. And I think this is fairly self-evident. If a party doesn't want to participate in mediation and try and attempt to resolve their disputes through the mediation, it's not likely that they will resolve their disputes. They must want to do this. The second is that there are discussions between these parties. Of course, inherent in all these discussions is the fact that there is, a dispute. There is a third person who's assisting parties in resolving these disputes, and the parties are working towards a resolution to the dispute. This process is also a confidential process, and the discussions that take place between the parties, proposals that the parties may make, the fact that parties may admit to a liability in the discussions, but there is no agreement at the end of this discussion, means that these discussions and these proposals and these admissions made or a draft agreement that the parties may draw up are confidential matters and cannot be taken out of the mediation and discussed in the context of a litigation or an arbitration. So these are really the gears of mediation. Just to sort of describe what the mediation process is, it is a very structured process. It is a negotiation, but it has a third person who's helping the parties negotiate a settlement to the dispute. The distinction between mediation and a two-party or a bilateral negotiation is this. The mediator convenes a meeting between the parties. There is hostility, there could be mistrust. There is definitely a lack of communication that comes about, or effective communication that comes about because there is a conflict or a dispute between the parties. The mediator helps in bringing the parties together to the table. And while this might seem like a practical function, it has great significance because just getting the parties to come together and to talk is a big step towards resolution. The mediator helps the parties to talk about their perspectives of the dispute, how the dispute came about, what was the history, what was the relationship between the parties. And the parties listen to each other, speak about what the problem is according to them. From this, the mediator helps them identify their interests. And when I say interests, what I mean is what is really in the interests of each person who is there as a disputant in resolving their dispute. For instance, you could have, I think you could have a dispute where money is owed. And the person to whom the money is owed needs the money immediately and is willing to give up in terms of the percentage of interest or interest completely, so long as the person receives the money immediately, because the person has a certain need for which the money needs to be used. So while the person's legal entitlement will be the sum of money owed together with interest at the agreed rate or at the rate that, say, an arbitrator or the law provides. But the person's interest is that, I want to get this money immediately and I'm willing to forsake some amount of interest to get this money back immediately. So this is the distinction between a legal entitlement or a position versus an interest. So the mediator helps the parties to come to or to identify what their interests are. With the interests known to the parties, the mediator helps the parties to generate options on how the disputes could be resolved. What are the ways in which each party thinks, what are the terms on which each person or each disputant thinks their dispute can be resolved. These options are generated by the parties, and at the end of it, the parties narrow in on options or resolution of the dispute that they find mutually acceptable. They reach a zone of possible settlement, and if the parties are in agreement as they work out the brass tacks or the details of this agreement, they then come to an agreement, and this agreement is drawn up and signed. So this is the process of mediation. It's a very structured process. It might seem ephemeral, persons talking together, coming to an agreement. It's not so. It is indeed very structured. So this is the process of mediation. Now, like arbitration, mediation is a private dispute resolution process. So we don't go to courts. It's not a public dispute resolution process that is happening in the courts. And like arbitration, it is a private process where the parties appoint a person to help them resolve their dispute. In the case of arbitration, the arbitrator will decide how the disputes will be resolved. In that, the arbitrator gives a decision on the issues that the parties have raised. The parties decide how the process will go. For instance, in arbitration, the parties can decide that it will only be a documents-only process, that there will not be oral evidence. The parties could, in choosing arbitration, the parties decide that the role of the courts will be very limited, that if there is an award that is given by an arbitrator, there will be limited grounds on which the court can look into or evaluate the arbitration award. Likewise, in mediation, you have a third person who is helping the parties resolve the dispute, but it is a facilitative role. In choosing mediation, the parties are also limiting the intervention of courts, because if once they enter into an agreement, they are to implement this agreement. Where the differences are between arbitration and in mediation are, one, in the role of the neutral. And this is something I mentioned. The neutral or the mediator does not decide the dispute. The mediator will not tell the parties how they should settle their disputes. It is for the parties to work out and decide how they will settle their disputes. Another distinction is the fact that the extent of party autonomy in terms of how they will resolve the disputes is not limited to the binary prescriptions that law states, that money is to be paid, not paid. And I will give you an example of a case that really took place in mediation in the Delhi High Court to sort of give you context to this, this point. There was a dispute by a very prominent manufacturer of apparels who said, and it's a very well-known manufacturer of apparels, who filed a case in the Delhi High Court saying that my trademark is being infringed by the small manufacturer in Punjab. And the party appeared before court and the court sent the case for mediation. During mediation, now if the case had remained in court, the court would come to a decision saying, look, this prominent trademark is being used by, and it was a registered trademark. This is a trademark being used by this this business person in Punjab, and they should not use it. And it's a violation or an infringement of the trademark. And we are issuing a permanent injunction restraining you from using this trademark anymore. So that is what the court would have done if the case went through trial and the decision was taken by the court. When it went to mediation and the apparel manufacturer and this business person who was using the same trademark in Punjab had a discussion. And over time, what this trademark owner found was that the quality of the apparel that this person manufactured under this infringing trademark was of a very good quality. So what they decided was that they said, look, we have this certain standards that products that are sold under our trademarks need to meet. Please continue making these products, but as a supplier to us, and we will sell the products that you make because the quality of these products are so good. And that is how they settled the dispute. So when I say the binary of legal prescription or legal entitlement, I mean, it's not you are right, you are wrong, but you could work out a solution that works towards the interests of all parties. So the question then arises, now this is a private resolution process, how much should there be a regulation of this private process? And you have similar issues as in the case of arbitration. A lot of you have followed what is happening under the Arbitration and Conciliation Act, where there is a constant tug-of-war of how much should the court regulate the process of arbitration, regulate appointment of arbitrators, what are the disputes that need to go to arbitration. Similar issues come up in mediation as well. What are the public interest issues that make the court or the parliament weigh in a mediation process to ensure the integrity of the process, for instance, to ensure that the mediated settlement agreement is in conformity with our law. So these are questions that arise. The question that comes up is, how much should we regulate? So when we talk about the draft mediation bill, this is a question that will keep coming up. How much do we compromise the flexibility of the mediation process by regulation? And where do we need to ensure that there are safeguards in the process? Different countries have adopted different ways of regulating mediation. In Singapore, what they have done is there is a Mediation Act of 2017, where the law prescribes conditions and ways in which mediators will be certified. There are mediation service providers. There are institutions that will train mediators in mediation. And these are accredited mediators. You can also have mediators who provide mediation services without such accreditation or registration. Once a settlement agreement is arrived at, the agreement can be taken to court by the parties. And the court will look at this mediation agreement with certain grounds or terms in mind. It will look at if, for instance, the mediation agreement concerns a child, whether the best interests of the child are met. It will look at whether the mediation agreement is in violation of any public policy principles under the law. For instance, does a party have the capacity to enter into a mediated settlement agreement? For instance, if there is a company that is under insolvency resolution, the company cannot enter into settlement agreements through its former directors or erstwhile directors. So these are aspects that the court will look into. And if it meets these grounds that are set out in the Singapore Mediation Act, the court then approves of the mediated settlement agreement, and the mediated settlement agreement has the force of the judgment of the court, and you can execute the mediated settlement immediately. This is the policy followed in Singapore. In Italy, they have a law that mandates mediation for certain categories of disputes. So before you file a case before court, you have to take it to mediation. The law has also taken steps to set up mediation service providers, mediation training institutes. There are regulations that govern how these service providers will conduct their mediation. And parties are mandated to go for mediation in certain categories of commercial and contractual disputes. They have to go for mediation. They have to participate in one session of mediation. And if they're not able to settle the disputes through the mediation, and then they take the case to court, and then the court will hear the dispute. But the parties have to participate in one session of mediation. And what has transpired over about 5-6 years of this law being enforced in Italy is that the cases in which, or the disputes in which you need to mandatorily take the case to mediation before you file a case, the filings have dropped by about 50%. And the reason is that parties have, by being forced to participate in one session of mediation, they have found that this mediation process has a lot of value, has a lot of merit, and they have settled their case. At the end of settlement, there is, of course, now no need to file a case. And the result is that there is a drop by about 50% in cases filed in this category of cases. The third policy approach to mediation is what is adopted in Ireland. Ireland has a Mediation Act again of the year 2017. Ireland sets out the process of mediation, and it sort of provides rules under this act which safeguards rights of parties that might adopt mediation to resolve their disputes. It has a mediation council that ensures that mediators follow a certain code of conduct that ensures that parties' interests are safeguarded. So it provides information, it provides a regulatory infrastructure for parties if they wish to choose mediation. There is oversight and there are safeguards that are provided. If parties enter into an agreement at the end of the mediation process, it is enforceable as if it were a contract between the parties. So these are some approaches that that countries have taken towards regulating mediation. We now come to India. In India, we have two laws that are sector agnostic. That is, they apply to mediation across different sectors. And over time, we've had a lot of laws and regulations that have introduced mediation in order to settle disputes. I will move to the next slide just to show the growth of laws and regulations that make a provision for mediation. So from two laws between 1900 and 1950, if you look at the last 2 decades, there is a spurt of regulations and laws that make a provision for mediation and conciliation in order to resolve disputes. So the question really is not, do we need a law on mediation? We do have a lot of laws on mediation. But what is it that we intend to do with this draft mediation bill? Why do we have, if we have so many regulations relating to mediation that regulate the process of mediation, why do we need another law on mediation? The reason for having the law on mediation is that, before I come to that, I'll give you a sort of a background on what the laws are relating to mediation. We have under the Civil Procedure Code, Section 89, which was introduced in 1999, which empowers the courts that hear civil disputes to look at the case. And if the court feels that this is a case that can be resolved through a settlement or through mediation, the court can refer the parties to mediation through court-annexed mediation centers that have been set up throughout the country since 2005. Like Anand mentioned, the Madras High Court set up the first center, but now you have centers in all the high courts, in most of the district courts, in family courts, in labor courts. You have mediation centers set up as part of the court structures. And these courts refer cases that the judges think can be resolved through mediation to these centers. The centers, through their panel of mediators, help the parties settle the dispute. And if it is settled, the agreement that the parties reach is sent back to the court. The court will look at the agreement to see if it is something that meets the requirements of law in terms of it is an agreement that parties have the capacity to enter into. It is not void under any law. That is in the sense that it is not an illegal agreement. And once the court is satisfied that this is an agreement that can be given effect to, the court will then pass a decree in terms of this agreement. So that is under the Civil Procedure Code. And all civil disputes, in fact, other disputes as well, under Section 138 of the Negotiable Instruments Act, family disputes, divorce cases, partition suits. So a lot of cases are being referred to mediation. We have what is called the Mediation and Conciliation Project Committee that was set up by the Supreme Court, which is the umbrella organization that oversees court-annexed mediation in India. They have trained mediators. I am one of the beneficiaries of such training. We have almost 10,000 trained mediators in the country under the MCPC programs. The second law relating to mediation is the Arbitration and Conciliation Act. Under Part 3 of this Act, there are provisions that govern conciliation. So what is the difference between mediation and conciliation? Mediation is, both are effectively the same process. But under Part 3 of the Arbitration and Conciliation Act, the mediator or the conciliator, as the person is referred to under Part 3, has a more active role in the mediation. The conciliator helps the parties to evaluate the merits of their case. So the conciliator is typically a subject matter expert. So if one were to have, say, a shareholders agreement, you would, on which there are disputes, you would have the conciliator being someone who is a person who knows the kind of disputes that come up in shareholder disputes. It could be a chartered accountant. If it relates to an engineering dispute, it could be an engineer who is called upon, who's appointed as a conciliator. So with the weight of this experience that the conciliator has, the conciliator will suggest ways in which the parties could resolve their disputes. The conciliator suggests possible terms of settlement to the parties. The parties could either accept it, make changes to it, or could disagree with the proposal given by the conciliator. But if the parties accept this, then you have a settlement agreement that the parties enter into. And what Part 3 of the Arbitration and Conciliation Act says is that such an agreement has the same force as an arbitration award, which means that it can be enforced as if it were a decree of court. So the benefit of going through conciliation and through mediation under Section 89 of the Civil Procedure Code is that you enter into a settlement through mediation or conciliation. And the effect is that this is like a judgment of a court, and you can enforce it immediately. The need for enforcement really is very low in settlement agreements through mediation. And the reason is this, that it is the parties who are working out the settlement agreement, right? So if I have a dispute and I'm participating in a mediation, I will agree to a settlement agreement that I think will work for me, that makes sense to me. And once the settlement agreement is entered into by me and by the counterparty, we will implement it because this is something we have worked out. This is something we have designed and we have agreed upon. And so I will give effect to it. I will implement it. I really don't need to use an enforcement mechanism to enforce this. But should I need something like this? Should I need an enforcement mechanism in the off chance that one of the parties does not implement the settlement agreement? The law says that you can enforce it as if it were a decree of court. So an entire portion of what is in a litigating landscape, that is filing a case, proving a case, getting a decree, is now done away with, and you can automatically execute this agreement, the settlement agreement. So this is what we have in terms of the law. We also have smaller laws that make a provision for mediation. We have, for instance, the Commercial Courts Act, which says that if you have a commercial dispute, and commercial disputes are defined under that law, you will first take it to mediation, pre-institution mediation. And if you're not able to settle it there, it is only then that you will file a case in court. So you have the Commercial Courts Act, you have the Industrial Disputes Act that makes a provision for conciliation of industrial disputes. You have the MSME Act, the Micro, Small and Medium Enterprises Act 2006, that makes a provision for settlement of first attempting to resolve disputes through conciliation. And if it is not resolved through conciliation, then you take it to arbitration. So there are a lot of laws that are making provision for mediation and conciliation. So why do we need a law? Again, question, why do we need a law on mediation? the multiple laws that we have make different provisions relating to mediation that, to my mind, compromise the integrity of or the essential elements of what the mediation process is. For instance, under the MSME Act, the Facilitation Council will conduct conciliation, and if the parties are not able to resolve the dispute through conciliation, they will move the dispute to arbitration. And the law makes a provision that the same Facilitation Council will do both conciliation and arbitration. And the difficulty with such a situation is this, that in a conciliation, in order to ensure that all issues are on the board and being discussed by parties, parties will make admissions, will talk very frankly and freely about what led to the disputes. So there could be a concession made by a party saying that, okay, I will not ask for everything. Let us settle at something less than what I'm entitled to. There could be admissions by parties that, okay, I owe you this money and let me see how I'm able to pay. Now, when the person who is acting as a conciliator now acts as an arbitrator, this person is privy to this private information that the party has made in the course of conciliation, and that is likely to influence the arbitrator in giving a judgment in favor of a judgment against or an award against the person who has made these admissions. So the law generally provides that the same person ought not to act as a conciliator and as an arbitrator, as a person who is helping them settle disputes, as well as a person who is deciding the dispute for parties. But you have some laws that make like the MSME Act, that affect the integrity, this integrity in mediation process. You have other laws, for instance, under the Companies Act 2013, which makes the provision for mediation. It says that after the mediation process, if there is no settlement, the law itself says that the mediator will inform the tribunal, the National Company Law Tribunal, or the central government, if it's a dispute that the central government will decide, will inform them about the reasons why the settlement did not take place, which again impinges on the confidentiality in the mediation process. So with multiple laws that try to meet the sectoral needs that have affected the integrity of the mediation process, it is important to have an umbrella law that will restate what is important to the mediation process. So that's one of the reasons why you need an umbrella law. The second reason is that the law relating to enforcement of settlement agreements in the private sphere, that is under Part 3 of the Arbitration and Conciliation Act, is not very satisfactory. While the law says that it amounts to an arbitration award and therefore it can be enforced as if it were a decree of court, there is no provision, for instance, if a party feels that they want to challenge the settlement agreement. For instance, if they feel that there was a fraud in the settlement process, there was a fraud in the mediation, and we'd like to question it now, there is nothing available under Part 3 of the Arbitration and Conciliation Act that helps them do this. There is also the need to professionalize mediation. Like I mentioned, we have about 10,000 mediators, trained mediators in the country. And in fact, even more if you look at mediators who have been trained by private institutions, mediators who have been trained outside the country, mediators who've been trained by the Institute of Corporate Affairs, which also has a mediation training program. There are many trained mediators in the country, but the users of mediation, companies, lawyers, individuals don't know that there are these mediators available, and they don't know that there is this process called mediation that is available to them in order to collaboratively resolve their disputes. So this is one of the reasons why you need a law that will talk about mediation, that will talk about professionalizing mediation. The third is something called the Singapore Convention. This is a convention that was approved by the General Assembly of the United Nations in 2018 and was signed by several countries, including India, in 2019. It has been ratified by the requisite countries, and it is now a convention that is in force. What the Singapore Convention does is that if there are commercial agreements that parties who are in two different countries or who have an interest in a third country, if they have a dispute and they settle their disputes through mediation, the Singapore Convention provides that signatories can make provisions, and the Singapore Convention sets out the rules for this, where a person can take the mediated settlement agreement to the other country And the courts in that country will recognize this agreement and they will enforce it in their country. So what if I enter into a settlement agreement with someone in Cyprus and the person in Cyprus has agreed to pay me that money, pay me a sum of money, the person does not do so. And if Cyprus and India have both ratified the Singapore Convention, I can take the settlement agreement to the courts in Cyprus and ask them to enforce it for me and to help me recover this money from the party in Cyprus. What the court in Cyprus will do is to evaluate the settlement agreement on grounds that are set out in the Singapore Convention. And if this agreement meets the grounds that are set out in the Singapore Convention, you have the weight of the courts and the weight of the state that will stand behind this agreement and enforce it to recover this money and pay this money to me. So the Singapore Convention is very valuable for cross-border commercial disputes that parties have entered into, where the parties attempt mediation and they have a settlement agreement. So we need a law that will help us when we ratify the Singapore Convention to implement the Singapore Convention. There are incidental issues that arise in mediation as well. If I participate in mediation, and this has taken a few months, the law of limitation continues to operate during the time that I am participating in the mediation. And if I run out of mediation of time in terms of the law of limitation, then I'm without a remedy if I don't enter into a settlement. So we need a law that will say that during the period that I am in mediation, the period of limitation will not run. It is kept in abeyance. We also have under the Contract Act as another example of incidental issues that the law needs to address. We have under the Contract Act a section called Section 28, which says that if you enter into agreements in restraint of judicial proceedings, I'm sorry, I've used the expression in restraint of trade. If we enter into agreements that restrain a party's ability to approach courts, those agreements will be void. There is an exception made in the case of arbitration, but we don't have an exception in the case of mediation. So if parties were to enter into an agreement where they say that they will attempt to resolve the dispute through mediation before they go to court, it is likely that this agreement may be treated as being in restraint of legal proceedings under Section 28 of the Contract Act. And therefore, one needs an amendment to the Contract Act to say that agreements where parties say that they will resolve the disputes through mediation should not be treated as an agreement in restraint of legal proceedings. So these are some of the reasons why we need a law on mediation. We now come to the Mediation Bill of 2021. Before I start discussing the bill, there was a bill that the Government of India put out for public consultation and for comments. This was in October 2021. There were comments received. Several of us sent comments on the bill. And there was a draft bill that was then moved before the Rajya Sabha in December 2021. This bill has now been referred to a select committee which will evaluate this bill and then bring it back to the Parliament. This is the bill that I'm going to discuss now because there are substantial differences between the bill that was put out for public consultation in October 2021 and the bill that was moved before the Rajya Sabha in December 2021. The first thing that the bill does is that it defines mediation. And in defining mediation, this is the definition that the bill has. And in defining mediation, the bill dispenses with this distinction of whether something is mediation or something is a conciliation and what those differences are. And the definition says that it does not matter what is the expression you use in order to describe this process, but so long as this process is a process in which parties to a dispute request a third person referred to as a mediator or a mediation service provider to assist them in their attempt to reach an amicable settlement of the dispute. This is what is mediation. So the Mediation Bill defines mediation as such. It, as a consequence, repeals Part 3 of the Arbitration and Conciliation Act. So this distinction where there is a strict process of conciliation, and what the problems were with the Arbitration and Conciliation Act and Part 3 of the Arbitration and Conciliation Act were, if I were to sort of identify two big problems with it, the first was the enforcement of the settlement agreement that I was talking about. And the second is that it is a very structured process under Part 3 of the Arbitration and Conciliation Act, where the conciliator has to conduct the conciliation process in a particular way. So like I mentioned earlier, the conciliator has to make proposals for settlement, has to weigh in on the merits of the case. So it was a very structured and in some ways a very inflexible process, because when conciliation agreements were taken to the court as high as the Supreme Court of India has said that unless you follow these processes to a T, where the conciliator makes a suggestion on how you will settle, reviews the settlement, this proposed settlement, the parties review it. And at the end of it, if you have a settlement agreement, it's only then that this is a conciliation process that will have the benefit of Part 3 of the Act, not otherwise. So it made it a very watertight and rigid procedure. This was a problem with Part 3. Now that is now out of the way. And whatever process the mediator or the conciliator adopts, so long as it meets the process that is set out under this law, it will amount to mediation. The second is that the bill describes the mediation process in some amount of detail. It talks about how the mediation process will be conducted. It defines a mediator as a person who helps parties resolve the disputes. It also includes mediators as persons who are certified under the law and who are part of a mediation service provider. It defines the mediation process. It says that the mediation process will be undertaken in a place which has the territorial jurisdiction, where the court will have a territorial jurisdiction over the dispute or the list. It defines the role of the mediator. It talks about a code of conduct for the mediator. It talks about the mediator not forcing parties to settle the dispute in a particular way. It places responsibility on the mediator to tell the parties that the process is an attempt to resolve the dispute, but there may not necessarily be a settlement, that the mediator will not make a promise of a settlement of the dispute. It makes a provision for a mediation agreement. That is, parties can, before the disputes arise, or even when they enter into a commercial agreement, they can have a mediation agreement where they decide that if we have disputes, we will resolve it through mediation. It says that the mediation process needs to be completed in 180 days. And the idea behind this seems to be that parties should not use the mediation process in order to protract the dispute. So it says that the mediation will be completed in 180 days, and if it is not done so, there could be an extension of 180 days over and above this first 180 days, but not more than that. It says that the courts can refer disputes to mediation. So even if there is no mediation agreement between the parties, it talks about registration of a mediated settlement agreement. And it says that if parties enter into an agreement, the settlement agreement will be enforced as if it were a decree of court. The Mediation Bill also talks about grounds on which the settlement agreement can be challenged. It says that if there is fraud, if there is corruption, if there is impersonation of parties in the mediation process, or if it is a dispute that is not fit for mediation, then the settlement agreement can be challenged on these grounds. And the challenge needs to be done within 180 days, within 90 days. And if it's not challenged within 90 days, then there can be an extension of time of another 90 days. But if you don't challenge within this period, then it is binding. It also makes a provision for registration, a compulsory registration of the mediated settlement agreement. And it provides for organizations or authorities to be set up in various places before whom the settlement agreement will be registered. Schedule 1 of this law also lists certain disputes that cannot be resolved through mediation. And these could be disputes relating to intellectual property disputes. It could be disputes where there are serious charges of fraud. It could be disputes where it relates to taxes. It could be disputes where the interests of minors are concerned or the interests of a deity is concerned. It could be disputes where the person is not mentally fit or incapable of discussing and resolving the dispute. So there is a list of disputes that are set out in Schedule 1 to this bill where these disputes cannot be taken to mediation. A very important part of this draft mediation bill is its mandating of mediation in certain disputes. And these are civil and commercial disputes where you must take these disputes to mediation. You must attempt mediation. And what the law says is that you must sit through 2 sessions of mediation. And if you're still not able to resolve the dispute, that is when you will file a case in court. The other aspect that is important in mandating mediation is that it makes a distinction from how mandatory mediation has been approached in the Commercial Courts Act. It says that all civil and commercial disputes must be taken to mediation. And it also says that if there is some urgent interim order that you need, and it also says that it must be in exceptional circumstances that you need urgent interim orders, you can apply to the court for the interim order. And once the court has taken a decision on the interim application, whether granting of an interim order or not, or refusing the interim order, the court will then refer the case back to the mandatory mediation. The parties now, after they've taken the interim issue to the court and got orders from the court either granting the injunction or refusing the injunction, the parties will take the dispute back to mediation and attempt to resolve the dispute there. So this is the big distinction. The mediation bill also says that if there are disputes that fall within the jurisdiction of the commercial courts under the Commercial Courts Act, it is Section 12, capital A of the Commercial Courts Act, which also has a provision for mandatory mediation, that it is that law that will apply and it is not the mediation bill that will apply. In a short while, I'll come to what this means in terms of distinction. So civil and commercial, this is a big game changer. All civil and commercial disputes will now have to go for mediation before the case is filed in court. The draft mediation bill also makes the provision for the establishment of a mediation council, which will regulate mediation. And the mediation council has powers to certify or approve of mediation services providers who will provide mediation services. It will also certify and recognize mediation institutions, and these are institutes that will provide training for persons to act as mediators. There are provisions for the mediation council being constituted, and it will have 7 persons. These are persons who will have expertise in mediation law, in alternative dispute resolution, who are teachers in mediation. These are persons who will form the mediation council. There will also be nominees from the government who will form a part of the mediation council. What is missing in the mediation council is mediators. So when I was talking about professionalizing mediation, it was the intention, it was the aspiration of mediators like me, that we have a mediation council which will comprise of mediators. It will be a self-governing body where we will promote mediation, we will set standards for mediation, we will set standards for mediators, we will make provisions for registration of mediators with the council, and we will self-govern. As in the case of other professions, we as a professional body will self-govern how we conduct mediations. But there is no provision for mediators in the mediation council. There is a provision for the mediation council to set up expert committees to take on certain functions. And possibly here, there would be mediators who would be part of these committees. But for the council itself, there is no provision for mediators to participate. There is a provision, a single section that deals with online mediation. The mediation council will make regulations relating to online mediation. There is also provision relating to community mediation, and this by community mediation, what the bill says deals with is mediation that takes place in neighborhoods or in communities in a local area. If there is some issue or conflict that disrupts the peace and harmony of this community, even say in apartment complexes, these persons will approach the district magistrate or the legal services authority under the Legal Services Act, Authorities Act, and the government or the legal services authority will have a panel of mediators, not necessarily trained or accredited mediators, but even persons who are respected and have a certain standard in the community, who will then resolve these disputes that are taking place in the community. So that is what the bill says about community mediation. The bill has a very strong provision insofar as mediating government disputes are concerned. So where the government is a party to a dispute, and we know that a huge percentage of disputes that are there in the courts involve governments, government agencies, and government entities. It says that government disputes involving the government, the central or the state government or the local authority, or government entities or government agencies will not be taken to mediation. It then makes it starts with saying that you will not, that government disputes will not be taken to mediation, and then it makes certain exceptions. It says that the central government may make regulations permitting certain disputes that can be taken to mediation. It says that if certain government agencies or entities have provisions or wish to resolve their disputes through mediation, that can be done. One example I'd like to give about, a good example of government disputes being resolved through mediation is what the National Highways Authority of India has attempted. And there is a provision for conciliation, a scheme for conciliation that the NHAI has, where it has set up 2 or 3 expert conciliation committees. Each of these committees have a retired judge, a retired bureaucrat, a retired or a very senior auditor. And these persons help in the settlement of disputes between the NHAI and concessionaires or contracting parties under public-private partnerships. And a lot of disputes, and I say this only on the basis of public information that has been made available in newspapers and in magazines, a lot of disputes between contractors and the NHAI have been resolved through conciliation. So while the bill starts with saying government disputes will not be resolved through mediation, you will not take it to mediation, it then makes an exception and says that certain agencies that have, that have guidelines or schemes for resolving mediations, they could take it to mediation. This is a big disappointment because with safeguards, government disputes can be resolved through mediation. We have seen that it is happening. And rather than encourage that, the draft bill says that these disputes, as a rule, will not be taken for mediation, but there are certain exceptions. The incidental issues that I was talking about in terms of bringing uniformity to the process of mediation, amending laws relating to limitation, these are changes that the mediation bill brings in. It says that while the mediation process is underway, the period of limitation will be suspended. It attempts process uniformity in that it says that if there are other laws that deal with mediation, they will need to comply with the standards of mediation that are set out under the mediation bill. But it also exempts certain other laws. For instance, the Industrial Disputes Act, which has conciliation, which has now been transplanted in the Labor Code. There is a provision for conciliation here. This provision for conciliation has its own sort of course of action, where the conciliator is government officer, a labor officer. The labor officer has the power to inquire, get information, summon witnesses, summon documents, ask for documents to be produced before the conciliator. The conciliator also suggests ways in which the workforce, the workers and the employer could resolve the dispute. All of this is unaffected by the law. So in certain sectors where a certain procedure is attempted in terms of mediation or conciliation, this law does not interfere with that. But overall, it says that other laws will need to conform to how mediation is prescribed under this mediation bill. The last part is the Singapore Convention. The October 2021 draft that was circulated made a provision for enforcement of cross-border or international disputes, international settlement agreements arising from mediation in commercial disputes. But strangely, the December draft makes no mention of the Singapore Convention. This is inexplicable. One hopes this will be addressed by the Select Committee. So broadly, this is what the draft mediation bill provides. So the important sort of takeaways from us for us are that it deals the thrust of the draft bill is for civil and commercial disputes. There is mandatory mediation that parties need to attempt, and if they're not able to settle, then they take it to the court or to arbitration that they've decided upfront will be the means of resolving dispute. There are of course sort of problems with the draft bill that I did mention. The first is that it doesn't deal with the Singapore Convention at all. This is important because when we are looking at India being a destination for persons to invest in, as Indian courts and Indian judicial system being places where disputes can be resolved, mediation taking place in India, we must have the support of the Singapore Convention for parties to have the confidence that in resolving international commercial disputes through mediation, they can come to the courts here to enforce this dispute. So that is another problem with the draft bill. The last point, and I think this is something that is of particular importance to us when we talk about civil and commercial disputes, it says that if the dispute falls under the Commercial Courts Act, it will go to the commercial courts and it will go to the dispute resolution process that comes under the Commercial Courts Act. Under the Commercial Courts Act, if you look at the provisions under Section 12, capital A, the autonomy of parties that have a commercial dispute to refer the disputes to a mediator or a conciliator of their choice is encumbered. Under 12A of the Act as it stands now, these disputes have to be taken to the Legal Services Authority. And the rules say that if parties don't turn up, then that's the end of the conciliation. This follows to some extent under the draft bill. It says that the Legal Services Authority is one of the agencies or authorities that will assist parties, that will be a mediation services provider. There will be other agencies that will, other mediation services providers that will be recognized by the government, and they can provide services under the Commercial Courts Act, which means that if I think that X is a good person to resolve the dispute that I have, but I don't want, but this person is not registered as a mediation services provider under the Commercial Courts Act, I don't have the freedom of taking this dispute to this person. So party autonomy is severely encumbered, and that I think is a failing under the draft bill. There are a few other inconsistencies as well, but I don't want to go ahead and talk about that just now. I will now hand it over to Savita if there are any questions.
Thank you so much, Chitra, but I do not see a single question. So I will request the audience, if they have any questions, to quickly put it in the chat box. And I can see why, because the presentation that you made. So even I had, questions as you were speaking, but each time you finished a slide, it kind of resolved whatever queries I had in mind. So I can understand why the participants haven't yet asked. So on my part, I'll just ask you if you could just shed some light on the stages in the mediation process. So when the mediation is initiated, I did hear that you did mention that the Act has addressed it. Could you just run us through the stages in that mediation process that is there?
So typically, the mediation process starts because of an agreement between parties. And this is an agreement that could be a part of the commercial agreement that they have, or this is an agreement that parties could arrive at where they say, we have a dispute now, let's try and resolve it through mediation. The parties then approach a person who they jointly agree, or one of them nominate, or they approach an institution, and the institution appoints the mediator. The mediator then convenes a meeting of all the parties, and the starting point is for parties then to give an information to the mediator and to each other about the genesis of the relationship, and then the genesis of the dispute and what really the issues are, and what it is that they seek to get resolved through the mediation process. In the parties typically sit together and discuss this. So each person is listening to the other on, what is the other person's perspective of what the dispute is, what their concerns are, and what it is that they would like to see resolved. So it is an information sharing session. The preeminence is given to the parties and not to the advocates or advisors. Mediation is a process where parties, there is a lot of emotion that comes along with the dispute. There is anger, there is mistrust, there is a sense of outrage, there is a sense that the person has been wronged in how things have have taken place, or by the other person. And so mediation also allows parties to vent this emotion and for each other to see that there is a sense of agreement, of being aggrieved and anger. And this helps, the venting itself helps parties to then move on. They know that they have been heard by the other party. The mediator then helps the parties move on from what has happened to how the parties would like to see this resolved. And the mediator speaks to the parties about what are the options, what are the ways in which you think you can resolve this? How do you think this should be resolved? Options are generated by the parties. Often the option that one party suggests, or the options that one party suggests, may be unacceptable to the other party. But when one breaks it down, evaluates these options, one then comes to something, an area where both parties are far off, not on principle, but really in terms of details of how this can be resolved. And with further discussions, then one streamlines what the broad range or the terms of on which the parties will be willing to settle their disputes. And this is then worked on by parties further. And then the details are then drawn up as an agreement. And this is the settlement agreement. The one aspect that I'd like to add here is that given that it is confidential, there are situations where one party is not willing to discuss certain things in the presence of the other party. And the mediator then convenes private sessions where she listens to one or the other party. And the discussions that take place in this private session are not shared in the joint session without the permission of the party who has shared this information in the private session. So this is really the life cycle of a mediation.
Okay. I do have a question from Dr. Ethirajan. So saying that the MSME Act details give protection to MSMEs. How much percentage of MSMEs in India got benefited because of mediation?
I would not be able to say what percentage did, but the government has a site called e-Samadhan for MSMEs. And if you look at the value, it's a huge amount of disputes that have been resolved through MSME. There are some complaints about the resolution of disputes by the Facilitation Council. And one of the very big complaints is the fact that the Facilitation Council conciliates and then also goes ahead and arbitrates the dispute. So that's been one big complaint, and there have been cases filed in the court, and I understand that this issue is now before the Supreme Court.
Thank you, Chitra. So I don't see any other questions. So without much ado, thank you so much for joining us. I do see one.
Yeah, one more question.
One more question has just cropped up, so I'm just going to take that up quickly. Asta asks, has mediation service provider been defined with an intention to promote institutional mediation, likewise institutional arbitration, and whether a mediation service provider can be a company?
Right. I'll answer the first question first. You are right. It is an attempt to institutionalize mediation, but it's also a way of sort of setting standards for mediation service providers who will be registered with the Mediation Council. And that's the intention of making this provision for a mediation service provider. We will know if a company or an LLP can be a mediation service provider when the regulations are drafted and they come into force. My sense is that yes, I anticipate that companies and LLPs could be mediation service providers.
Okay. Anand has a question. Anand, do you want to unmute and ask? Anand can't hear you. So Anand actually, so his question was with respect to, actually Mr. Krishnan had a question that in a cross-border dispute, can the mediator be a person of foreign origin?
Yes, Mr. Krishnan, mediator can be a person of foreign nationality. In fact, the draft bill says that a mediator, even in India, even for domestic disputes, can be a person of foreign nationality.
Okay, so Anand says that the bill provides for a mandatory mediation. Internationally, does any other country provide for mandatory mediation?
Yes, there are a few countries that provide for mandatory mediation. Italy, as I mentioned, provides for mandatory mediation in certain commercial disputes. Turkey provides for mandatory mediation in employment disputes. Several countries provide for mandatory mediation in custody disputes and divorce disputes. There are countries in Europe that make a provision for mediation in insolvency resolution. They say, please take the dispute, or please take the insolvency resolution to conciliation. And if it's not resolved in conciliation, that's when you file the case before the authority that or the court that deals with insolvency resolution. So there are several countries that make a provision for this.
So there's a lead up also that in order to make it more effective, should mediators be empowered to impose a cost on a party who was not earnest?
This is a very difficult question. There is a provision in the mediation bill for the court to look at imposing costs. One of the sort of countries which has attempted this is England. Their rules of civil practice say that if a party does not attempt to resolve their disputes through mediation or through alternative dispute resolution processes, at the time when the case is decided and when the issue comes up of costs, you will know that in England, cost follows the event. That is the rule that they follow. So if a party wins the case, that party is entitled to the cost from the losing party. But what the civil rules of practice say is that if you don't, attempt mediation reasonably, then without a reasonable justification, if you don't attempt mediation or if you don't participate in the mediation, reasonably with a view to attempt to settle the dispute, you may not get the costs if you were a winning party. This is a way in which they've tried to encourage mediation. There is a lot of jurisprudence around this. And that's one country that has attempted it. I can't say with how much success, but I don't think a mediator should have that power. I think you're on mute, Savita.
Taking the last question for today. So whether the requirement in the draft bill that the mediator shall communicate the view of each party to the other to the extent agreed to by them could give rise to conflict of interest, besides striking at the requirement of confidentiality in a mediation process?
I think not, because it is a party that is instructing or allowing the mediator to share the information. Without the instruction of the party, without the authorization of the party, the mediator cannot share this information. So for instance, if a party has said that, I'm willing to accept 75 lakhs instead of 1 crore in settlement of this dispute. That was my original claim. The mediator and says, but just keep it to yourself. I want to see how this goes. And the other party, says, I will pay 70 lakhs to settle. The mediator can then get the permission of the first party to say that, look, I think there is a possibility of settling this. Will you be okay if I shared this information with the other side, or you could share it with the other side as well? And between 70 and 75, there isn't too much of a difference when you look at 0 and 1 crore. right? So it's only with the permission of the party that the mediator will share this information. So
I
don't
guess
think
it comes with certain skills, to be an effective mediator also. So you know what to say and how to actually gain the confidence of both the parties and make them meet.
Yes.
So thank you so much, Chitra, for a wonderful presentation. It not only gave us a lot of insight on mediation as a process, but also made us understand what the whole mediation bill is about and the fact that there is a lot of traction on this. I think India has come quite far looking at a lot of alternate dispute resolution mechanisms. And this is definitely a step in the right direction. Of course, like you said, there are a lot of little, I would say, sore points as far as the bill is concerned, which should get essentially assuaged as it goes along. But thank you so much for a wonderful presentation. So on behalf of the Madras Chamber, as well as the MCCI Arbitration, Mediation and Conciliation Center, thank you so much.
Thank you.
So with
Thank
that,
you for having me. Sorry, thank you
Yes.
for having me. And given that MCCI and MAMC are front runners in ADR, I think if you could look at the draft bill and send in your representations on how you would like your constituents to see the mediation law. It will help all of us as stakeholders in this process. Thank you so much.
Thank you. Saraswati ma'am, you're on
Thank you.
mute.
No, sorry. I just wanted to say a big thanks.
Thank you.
Thank you. Thank you, everyone. Good evening.